Thank you, Pam and Matthias. Hello, everyone, and welcome to our session on changes to the Construction Act. I'm Mark Javidoni. I'm a partner in the Hamilton office of Gowling WLG, where I practice in real estate, construction, and lending.
Hi, my name's Kevin Columbus. I'm an associate lawyer with Gowling WLG's Hamilton office, and my practice focuses on construction lien litigation.
Just a reminder that if you have questions throughout our session, please post them into the chat. We'd like to start off our presentation with reference to the Gowling WLG's construction hub. It's a convenient location on our website that houses a number of forms, precedents, tips, and links to the legislation to help navigate the changes that have happened to the construction industry in the last 2 years. Essentially, the Construction Lien Act has been amended to the Construction Act effective July 1st, 2018. The first round of changes started modernizing the Construction Act. The last real refresh wasn't since the mid-'80s. So the changes that came into force July 1st of 2018 refreshed the thresholds, the monetary thresholds for substantial performance, some definitional changes, and the changes to the timeframes for release of holdback and preserving and perfecting liens. The transition rules are important to note because it's important to verify whether the construction project itself is under the new rules or under the old rules. The transition provisions suggest that if the prime construction contract started, was entered into on or before July 1st, 2018, or was procured before that date, then the old construction lien rules will still apply. This is important when you're navigating the project and ascertaining whether or not the new rules will apply because your loan would necessarily be impacted by that. So the first item is always, which legislation are we following? We have a top 10 list of sorts of the top 10 changes that you should be aware of when addressing construction loan financing. The first item is the definition of improvement, which has changed. It reflects the changes that have been confirmed through the jurisprudence over the last 20 years or so. But now the definition of improvement includes alteration, addition, or capital repair to the land. And a capital repair excludes normal routine maintenance that's performed in order to prevent the normal deterioration of the land or the building or structures. So loans relating to normal routine maintenance upgrades may not actually qualify as an improvement. One of the key items that has changed is how liens are registered, preserved, and perfected. Under the old Act, you had 45 days to register a claim for lien. Under the new Act, that's up to 60 days. Similarly, under the previous legislation, you had an additional 45 days to commence and register a certificate of action to perfect the lien, and now that's 90 days. So the entire lien period from inception to the last day to perfect is 150 days. That timing has been introduced to accommodate the prompt payment provisions as well as the adjudication provisions that we'll be talking about later. The third item is the introduction of a number of forms. Every step along the way requires a statutory form to be used, so it's important that you become familiar with these. For sake of convenience, we've included a number of the forms on the Hub website that we have, but you should also bookmark them in the event that you need to use them or you need to be aware of what the form is doing or saying if you ever get served with one of these items. The definition of substantial performance has also changed. It's reflected the monetary thresholds that are a bit more modern. Previously, substantial performance was established when the improvement was ready for its intended use and it's capable of completion, or where there's no known defect, correction would cost no more than 3% of the first 500,000, 2% of the next 500,000, and 1% of the balance. Now those thresholds are 3% of the first million, 2% of the next million, and so on. So there is a possibility that substantial performance will be met sooner or earlier than in the past. This is important to keep in mind as final construction holdbacks are contemplated. The release of holdback is another important element because the Act has been modified to statutorily confirm that an owner is obligated to release the holdback at the end of the holdback period. It's still possible for an owner to refuse to pay the holdback, but there's a corresponding form in order to provide notice of that, and a certificate to be published in order to make that known publicly that the holdback is going to be refused. From a lending perspective, you would want to know if that's happened or not in order to prep yourself for the final release of holdback. Similarly, if an owner hasn't made an application to do that, anybody else can actually apply to the court to seek a certificate of substantial performance. The other element that has been modified to ensure that a number of court decisions have been reflected into the legislation now is the language relating to trust funds. The holdback has always been established as a form of trust, and now there's significant language and trust provisions in the Construction Act that demonstrate that when you're holding back funds, that it should be held in trust. These funds can be traced. There are fiduciary obligations relating to how those funds are held, monitored, and accounted for and applied. So that creates a statutory obligation as well. Anybody who is required to hold back funds must do so as a trustee. This is important for construction financing because as you are holding back 10% of advances, that 10% is being held in trust. One of the newest changes that came into effect in October 1st of last year is the prompt payment regime. The prompt payment requires payment to be made in essence within 28 days of receiving a proper invoice. This notion of a proper invoice has a statutory definition but can also be amended and added upon in the course of the actual construction contract. So it's important to understand what the parameters are for a proper invoice to then establish when it was received and when the clock starts ticking for making these payment arrangements. Parties can't contract out of the prompt payment regime. So it's important that lenders appreciate that. It doesn't matter how big or how small the project is, that the prompt payment obligations are mandatory. And assuming that there's no concerns with the form of payment draw that's been requested and that the proper invoice has been legitimately delivered, it would look like this. You would have the proper invoice landed, and that becomes day 0. Within 28 days, the owner then has to pay the contractor in full, less the statutory holdback. So from a lending perspective, you would advance to the owner. Owner would advance to the contractor. The contractor has to pay the subcontractor's amounts that are payable, less that holdback, within 7 days of receiving that from the owner and so forth down. So that by the 42nd day after the proper invoice was issued, everybody has been paid. There are situations where an owner may dispute a proper invoice, and if that's the case, a formal notice of non-payment has to be issued. Where that happens, the payor has 14 days to issue that notice, disputing the amount that's in the invoice in full or in part. A contractor who receives that must within 7 days start file a notice of non-payment down the chain, and within 21 days start an adjudication to preserve rights under that regime. My friend Kevin will be talking about that very shortly. So within 28 days, all parties in the pyramid will have received a notice of non-payment or a notice of adjudication, as the case may be, where there's a dispute as to the proper flow of funds. So the proper invoice has some provisions about what it has to include at a minimum. It also has some room to have a contract amend and upgrade the requirements for that. But it's important to note that you cannot have a proper invoice be conditional on an architect, engineer, or some kind of certifier certifying and verifying that the work has been completed prior to issuance of the proper invoice. That's an important element because the proper invoice will be issued prior to having the work that's on the basis of that invoice certified as complete. That's where the 2-week period starts to really become critical, because if the work hasn't been established to be correct or has deficiencies, you have 2 weeks to figure that out before you would issue a notice of non-payment. Now I'll turn the conversation to my friend Kevin to talk about the balance of the top 10.
Thank you, Mark. So what is interim adjudication? Interim adjudication is based on the UK's model for cheap and quick construction contract dispute resolutions, which has been in place for over 20 years. This is important as the prior dispute resolution process under the Construction Lien Act had attracted a lot of criticism. Under the new Act, parties to a construction contract will be entitled to refer disputes to adjudication that flow from a proper invoice under a construction contract. As with the new prompt payment regime, the interim adjudication provisions apply to contracts executed or procurement processes commenced with respect to an improvement on or after October 1st, 2019. An adjudication has to be started before the date the construction contract between the parties is completed, unless the parties to the contract agree otherwise. And while mandatory, parties remain free to draft their own dispute resolution provisions in their contract, as long as those provisions are consistent with the new Act. So, if your borrower is served with a notice of adjudication, you need to consider what impact that would have on you and your future draws. Dispute resolution provisions here are designed to be fast and allow the project and work to continue without interruption, business as usual. But you should ensure you are aware of the particulars and current status of any interim adjudication with respect to your borrower, so you're aware if fundamental problems arise. So what can you adjudicate? A party to a construction contract can only commence an adjudication against a party with whom it has a contract. So a subcontractor cannot start an interim adjudication against an owner. Now, a party who wishes to refer a dispute to adjudication has to give the other party written notice, a notice of adjudication, which includes names and addresses of the parties in question, a nature and brief description of the dispute, including details regarding when and how it arose, the nature of any redress sought, and the name of a proposed adjudicator to conduct the adjudication. Anytime after notice is given and before the adjudicator makes their final determination, the parties may agree to consent to terminate the adjudication. So this chart outlines how quick an adjudication process can take. So from when the first party delivers a notice of adjudication to the party with whom they have a contract, the receiving party has 2 days to determine if they agree with the proposed adjudicator. Thereafter, within 5 days of the selection of the adjudicator, the party who started the adjudication must provide the adjudicator and responding party with copies of the contracts in question and any other documents they intend to rely upon. The adjudicator thereafter must release his or her written decision within 30 days of receipt of those documents. This time may be extended at the adjudicator's request with the written consent of the parties for a period of no more than 14 days. Or, if the parties agree to and the adjudicator consents, the period can also be extended. Otherwise, if an extension is requested after a determination is made, it will be of no force and effect. So, within a period of 45 days, the entire adjudication process should be completed. So it's in a period much less than even the lien period for preserving your lien. So how does it work? Adjudication process is initiated if a party to a contract or subcontract wishes to refer the dispute to adjudication. They need to give the other party a written notice, and the adjudication cannot be commenced if the notice is given after the contract or subcontract is completed. Anytime after notice is given and before the adjudicator makes their determination, the parties can consent to terminating the adjudication. In terms of appointing an adjudicator, the parties cannot agree on their adjudicator beforehand, and the adjudicator proposed must consent to their appointment. The ADR chambers, now operating as the Ontario Dispute Adjudication for Construction Contracts, or ODACC, provides a list of approved adjudicators on their website. An adjudicator's determination is binding, so a party to an adjudication may file a certified copy of the determination with the court, at which point the determination is enforceable as if it was an order of the court. The decision may be filed within any time within 2 years of receipt of said decision, or within 2 years after a final determination of an application for judicial review, which I'll discuss later. Until a later determination of the court, the determination of an arbitrator is made or executed respecting the matter which is subject to the adjudication. Additionally, if an adjudicator's decision to pay is not obeyed, the party expecting payment would be entitled to suspend work under the contract or terminate their contract. Payment under a determination is required within 10 days of receipt of the determination, so it's a quick turnaround. And parties to an adjudication are typically required to bear their own costs unless one party acted in a vexatious or abusive manner. Applications for judicial review can be made to the divisional court via a motion for leave with proof of service. This step must be completed no later than 30 days after receipt of the adjudicator's determination, and the divisional court may dismiss the application for appeal, judicial review, without reasons, and there are no appeals from a motion for leave. Further, an application for judicial review does not operate as a stay of the determination, and interest will continue to accrue against the party who is ordered to pay. Now, I'm going to provide some examples of some key Construction Act forms and documents so that you are aware of what they look for if your borrower is involved in either a construction contract or an adjudication. So, this is an example of a proper invoice. This is not a set form, but a precedent we uphold with generic information. As you can see, it includes the names of the parties, description of the services, the property where the project was taking place, as well as details of what work was completed. And here is a notice of non-payment form. These are available online. This is form 1.4 for notice by a subcontractor. All these forms are available online. And here is a notice of adjudication. It's a template form available by the ODACC on their website. And as you can see, it sets out the parties to the dispute, the nature of dispute, and a brief description. Now this would just be page 1 of 3 for the form. And I'll now be turning it back over to Mark to discuss how you can take steps to adapt to the new Act.
Thanks, Kevin. The flow of funds will be rooted in the relationship that you have with the borrower. The borrower and the lender's relationship become pretty critical in the context of a development. Constant communication is going to be critical to navigating these challenges and to better understanding what's happening in the regular course of construction, but also in the certification throughout addressing the disputes as they arise before they turn into the more formal elements of the Construction Act. Typically, when you are advancing in installments for a construction loan, you'll often utilize a checklist of sorts. Do I have these 12 things in order before I can authorize the release of the funds to the borrower, to the owner? That checklist is probably something that you should be refreshing in light of the changes that are happening to the Construction Act right now. For example, you may not get a statutory declaration that the improvements for that draw have been completed. Absolutely. You would need to know what a form of proper invoice is for each project. It's not the same for every project, although they'll be similar. So it's important to understand that and ask that at the outset so that you are understanding that the funds that are being requested are backed up by a proper invoice and the clock starts ticking. The payment has to be received by the contractor within 28 days. So the funding element has to be made, assessed, reviewed, approved, and issued and received within that period of time. Frankly, it might even be earlier than that as well. But 28 days is now the cap for the completion of payment for the prompt payment regime. You also need to be copied on all notices of non-payment that are issued by the borrower or that are received by the borrower. This is so that you, as the lender, are kept informed on subsequent concerns relating to payment or non-payment. Lenders who are slow to respond to draw requests could be embroiled in the issues, the disputes relating to non-payment down the chain. If a lender can't get its funds out within the first 14 days, the borrower owner may be liable to the other parties down the chain for not making payment and not issuing a notice of non-payment in time. Significant interest charges could apply. So it's important to be diligent on the timing as well. The prospect of a lien being registered isn't the primary focus anymore. The primary focus is making payment within the prompt payment regime. Construction contracts will still typically have language authorizing or requiring parties to vacate and bond off liens in the interim so that they can be moved to the courts to resolve. But with the adjudication regime, that is intended to take the place of a number of interim construction lien registrations, as well as court disputes for routine issues. You should be integrating your full team for construction draws. From funding to credit to legal, communication is critical to better understanding how this will work and how this will better assist your clients as well. It's important to consider potentially updating your credit agreements, your term sheets, to ensure covenants that the notices of non-payment or notices of adjudication are provided to the lender for assessment, that backup is produced for all draws on subsequent draws if certification can't be made on the subject draw. You want to know that it's always going to be backed up. An evidence of payment of an adjudication order has been made. You want to make sure that that's done before subsequent draws are being advanced. Evidence that no bonds have been called in. And beef up the indemnification provisions that are going to be necessary going forward. That and other considerations are important while trying to assess these changes to the Construction Act that are going to impact how lenders typically advance on construction loans. Kevin?
So we'd like to thank you for attending our session today and remind you that our Q&A session will be at 4:30 p.m. today. So please join us for the Q&A session if you have any questions based on our presentation. I'd like to thank Matthias and Pam for hosting us and thank Mark for preparing this presentation with me, and thank you all for joining us.
Thank you.